Anwar was formerly employed by a Scottish charity. She brought a claim under the Equality Act 2010 in the Employment Tribunal against her former employer and her former line manager for workplace and work-related harassment on the grounds of her sex, her race, and her religion. She succeeded in establishing liability in her claim and went on to obtain from the tribunal an award in excess of £74,000. She has not been able to enforce that award and alleges that her employer deliberately dissipated its assets to avoid having to pay her. Having faced that serious disappointment, she brought a petition for judicial review against the Advocate General, representing the Secretary of State for Business, Energy and Industrial Strategy, in which she contends that the United Kingdom has failed properly to implement two EU directives, which I will refer to as the Equality Directives, by failing to provide effective interim protection of such claims, and she has claimed compensation for that failure. The Employment Tribunal has an exclusive jurisdiction to hear claims such as the ones which she made. Her complaint is that our domestic law should have empowered the tribunal to give her an interim remedy of a warrant to arrest her employer's bank accounts on the dependence of her claim and thereby prevent what she alleges was the deliberate dissipation of its assets. The Lord Ordinary in the Outer House of the Court of Session dismissed her petition, and the Inner House dismissed her appeal by majority. She appeals to this court with the permission of the Inner House. This court unanimously dismisses her appeal. In doing so, it addresses two principal questions. First, it considers whether the Court of Session or the Sheriff Court has power to grant a warrant for diligence on the dependents on an application to the Employment Tribunal under the Equality Act for such discrimination and harassment. This court determines, in agreement with the majority of the Inner House, that the Court of Session and the Sheriff Court do have the power to grant such an interim remedy in support of a claim being pursued in another tribunal. That power does not depend upon the court having jurisdiction to determine the merits of the dispute. The court rejects the argument that amendments to the Debtors Scotland Act 1987, which were enacted in 2007, have removed any such power. That is a misreading of the 2007 reforms, which altered the procedures to be followed in obtaining such interim orders in order to protect the property rights of defenders against whom such orders were sought and to comply with their convention rights under Article 1 of Protocol Number 1 of the European Convention on Human Rights. Those reforms did not affect the ability of the courts to make such orders in support of proceedings in another tribunal. As a result, a third question, which was whether the absence of any such power is a breach of European Union law, does not arise. The second question which the court addresses is whether the requirement for an applicant in an employment tribunal claim to raise separate court proceedings in order to obtain the interim protection of an arrestment on the dependents constitutes a breach of the EU principles of effectiveness or effective remedy. The court concludes that it does not. The court recognizes that the applicant has to engage in certain procedural steps, incur additional costs in raising separate court proceedings, and expose herself to an adverse award of expenses. But the court considers that those additional hurdles are proportionate when one has regard to the potential for an arrestment of a bank account to disrupt or even to destroy an employer's business. The court rejects the claimant's further submissions relating to EU law. First, that EU law requires claimants vindicating rights derived from EU law to be given a, and I quote, one-stop shop. And secondly, that the court's powers to grant interim measures in support of employment tribunal proceedings must be expressly stated in legislation rather than be a creature of judge-made common law. It concludes that the requirement to obtain the interim protection from a court did not render Ms Anwar's EU law-based rights practically impossible or excessively difficult. Accordingly, there was no breach of the principle of effectiveness. The court also rejects Ms Anwar's assertion of a breach of the EU law principle of equivalence. It holds that the correct comparator in relation to her claim is a claim before the Employment Tribunal which is based on domestic law rights, such as unfair dismissal. As the tribunal has no power to grant warrant for arrestment on the dependents in support of a domestic law claim or a claim based on EU law, the principle of equivalence has not been breached. For these reasons, the court dismisses Ms Anwar's appeal. The court will now deal with two judgments which were promulgated respectively in August and September. As the court was not then in session, hand-down videos were not recorded, and we deal with those matters now.